A very good afternoon, ladies and gentlemen. Thank you for tuning in. Hope you are having a pleasant day. With that, I would like to welcome everyone to the Real Talk webinar brought to you by the Excel Academy of Real Estate. Whether you're a seasoned pro or just dipping your toes into the world of real estate, the Real Talk webinar is your golden ticket to learn from industry experts who have navigated the ever-changing real estate landscape, gain access to their insider knowledge, and stay ahead of the curve with up-to-date market trends. Joining us today, we have Mr. Leong Weng, who is a partner of Tuang, Chee and Co., to speak on the topic of from trust to betrayal, agent principles, accountability, and best practices. If you have any questions for Mr. Chee, feel free to leave them in the Facebook comment section below, which we'll address in the Q&A section at the end of the show. Without further ado, join me out welcoming Mr. Chee. Welcome, sir.
Hi. Thanks, Alpha. Thanks for the kind introduction. First of all, I'd like to say thanks again to Excel Academy for having me on the show. This time around to share more on topic of agent and principal. I understand from Alpha that some of the audience, or some of you guys are actually agent, which are property agents, I presume. So I think this topic will be interesting and relatable to some of you. And for the rest, I would think it will also be relevant because at one point, surely you have to deal with agent, be it, for example, if you're looking to buy houses or to sell house or to rent out your houses or even for your businesses, you will definitely come across agent, or you may, and you may be a principal yourself. Personally, I have a trial late last year, which actually involved the issue of agency as well. Now, what happened there was, it was a typical tenancy dispute. The agreement says that the tenant have to rent the tenancy for 3 years, and if you want to terminate earlier, you can, but you have to give the requisite notice. So what happened in that case was 1 year in the lease, the tenant actually terminated the lease. So what happened was then the landlord bring an action against the tenant, seeking for the remaining 2 years of rental. Now, the tenant's case in that case was that I have given the required notice under the agreement. During trial, when prompted, what we have realized or noticed was the tenant's case was that the notice was not given to the landlord. What they are saying is, I've given the notice to the agent of the landlord. And this agent is the agent which have assisted the landlord to secure the tenant. So being a property owner, when you're looking for people to rent your house, of course, most of the time you engage an agent. And in this particular case, the agent actually found the tenant, they rented the place. And when the tenant actually want to terminate the tenancy, instead of giving the notice to the landlord himself, is given the notice to agent. So then it begs the question, is this sufficient notice? Is the agent still an agent per se? When actually he's only engaged to help you look for tenant, and the tenant, has been concluded and they've engaged, does he still have authority to receive notice on your behalf? So these are some of the issues that we aim to discuss today. So without further ado, I will just summarize what are we going to cover today. For the first part, we will just quickly go through what agent and principal is all about. What are the types of agent, and then the next part, we also go through the duties of an agent and a principal, which will be very important, especially for those of you who are agent here. Many of you, some of you may not even know that you have such duties, and it is important for you to know that you have this duty and you carry out these duties. So for part 3, then we will move to a more interesting part, which deals with your case FAQ. So what we'll do is we will look at some actual cases which have gone to court. We will explore some important or relevant question. For example, must there be a written contract for there to be an agent and principal? What happens if an agent exceeds the authority that's been given to them? Are you as a principal bound by whatever the agent do, even if he does such act which is beyond the authority given to him? And also we discuss questions like, how do you terminate an agent and principal agreement? At this point, I would like to say it's important for us to know about all these cases, because the saying, as everyone say, we are all geniuses in hindsight. Why is that so? It's because we always have precedent to look back to, and to learn from it, to avoid any issue. So I guess this, if at all, of course, I will ask and urge everyone to pay attention to the entire session. But if you really have to focus, I would say part 3 is the interesting part which you should really pay attention to. Of course, then part 4, I will just briefly highlight some of the key takeaways and practical tips for both principal and agents, at least something that hopefully you'll take away from this talk. Now, moving to my first part, what is principal and agent relationship? There are many definitions to it. I've put up a few, which you can see on the screen. One has defined by the Cornell Law School is principal-agent relationship is an arrangement in which one entity legally appoints another to act on its behalf. Whereas also, of course, the Contracts Act, Malaysian Contracts Act, also define what an agent means and what a principal means. An agent is essentially someone which you employ to do any act for another person or to represent another in dealings with third person. And the person for whom such act is done or is so represented is called the principal. To put it simply, agent is essentially someone you authorize to act on your behalf and to deal with third party. And usually this happens when you as a principal, you do not have time or expertise to do it. For example, when you buy index fund, your fund manager is your agent. And why do you engage fund manager? Because you really just don't have the time to do research on what shares to invest in, what are the funds to invest in, and neither would you have the expertise, which is why you engage a fund manager. He will decide for you what fund to buy, what fund to sell. Another example is, for example, me as a lawyer. You engage me as your lawyer. I'm to a certain extent your agent in court. So whatever I argue I'll be arguing on your behalf. And of course, some footballer and athletes, you have agents as well who help you negotiate contracts or to help you, move to other clubs and etc. etc. Of course, the most relevant one today will be, property agent. Be it, an agent to help look for buyer, help look for seller, or even help look for tenant to lease your property, or even property agents to help manage properties. So these are examples of some example of principal and agency relationship. And now we move on to the type of agent. There are different, under the law, they recognize the different type of agents and they all have different power. So for those of you, who is considering appointing agent, be it property agent or agent to help you sell certain products or whatever not, it may be important for you to know and to know the difference between these types of agency, because the law might treat them differently as well. So as far as agents is concerned, there's 3 types in general. One, special agent. Second is general agent. And third is universal agent. So what are the difference between these 3 types of agent? Now, I've briefly summarized the differences. Of course, this is just a very simplistic comparison. If you were to dive in specifically, there's more distinguishing factors between these agents. But for purposes of the talk today, I've briefly summarized it. Now, starting off with special agent. What is special agent? Special agent is essentially someone you engage, an agent you engage to complete only a limited or specific objective. And these are, for example, your property agent, the most common one, where I engage you solely to help me find buyer. These are special agent, and they do not have authority to bind. What does authority to bind mean? It means me as an agent, I don't have the authority to bind you to any decision. I cannot sign any contract on your behalf. What I merely do is to bring the prospective buyer and introduce to you. Ultimately, the contract is still signed between the buyer and the seller. I do not have any authority to bind you. So that is the key distinguishing factor of what is a special agent. Now, moving on, what is general agent? General agent has a little bit more power as compared to special agent, and usually they're engaged for specific transaction. For a fixed period or for a specific area. It's not confined to only one specific objective or one specific event. It's an ongoing one. And more importantly, a general agent has the authority to bind the principal. What does it mean? It means I can actually enter into contract on your behalf. The examples that I can think of is, for example, your employees. Some of your directors may be an agent of the company. They can sign contract on behalf of the company. Those may fall within the definition of a general agent. Now, moving on to the most wide type of agent, which is universal agent. It essentially has broad or close to unlimited mandate to act on behalf of the principal, where you have to give them power of attorney. Example is, for example, when someone is of unsound mind, they cannot think, they cannot operate, they cannot think independently. You may apply for power of attorney to act on behalf of the person who's of unsound mind. In that case, you will be an agent. And of course, there's unlimited authority to be bound as well. So these are the three types of agent. But ultimately, as far as which type of agent you fall within, I've of course given specific example for each type of agent, but please bear in mind, ultimately it all depends on the terms of your agent and principal agreement. Even property agent, you may contract to say, you can even sign contract on behalf of the landlord. So then you would then become a general agent maybe. So I'm just giving some examples. It is not exhaustive. And ultimately, you still have to look at that precise case and the precise power that each agent has. Now, from all this agency, type of agency, that this, of course, then it sparks a lot of discussion, which we'll try to explore today. What are these discussion? Number one is, how do you appoint an agent? There are three types of agent. Then the question is, okay, then how do I appoint that? Does it have to be in writing? Can it be verbal? And of course, you also want to know what is the extent of the agency authority. This will, of course, depend on the type of agent you appoint. With universal agent, you have wide powers, general. For example, if you appoint a fund manager to manage your fund, can they also go beyond and handle your property and help you sell your property? Of course, you cannot. But as far as fund managing is concerned, is there any limit to his authority? Is there certain transaction that he needs your approval, or certain transaction he doesn't need your approval? All this is bad. It's important for you to know, so that you as an agent, what is the limit of your authority. You don't act beyond your authority, because if you act beyond your authority, the repercussion can be far reaching, which we also aim to discuss today. And then, of course, you will also want to know, okay, how do I end the relationship? I no longer want him to be my agent, because the relationship turns sour, or whatever reason, you may not want them to still go around representing themselves as your agent and doing things on your behalf. So you want to know, how do I make it clear that I no longer want you to be an agent? Of course, then the last point which I've mentioned is principle bound by Agents Act. If they act beyond the authority, this is very important. You will want to know, if you contract them to sell one house, and they go and help you to say, okay, I also promise to sell 2 houses. Are you bound to sell the second house? This is also something that we'll explore today. But before we go into all these pressing questions, which I'm going to go into, let's look at some of the duties as an agent and principal. Now, the list that I'm going to set out is not exhaustive, meaning it's only some and not all of the duties. Again, and the nature of the duty may also differ, because ultimately it still depends on your contract between your agent and your principal. I'm only highlighting some of it. Now, to start off is an agent's duty. As an agent, you owe what we call a fiduciary duty. For those who are in the agency line or in the legal line, I think you're quite familiar with this. For those who are not, to put it simply, it means as an agent, you must carry out your task with the principal's interest priority. What does it mean? Because as agent, you have your own self-interest as well, of course. If you manage to sell the house, you get commission or you get salary, but you must remember your duty ultimately still rests with the principal. You cannot, put your own self-interest on top of the principal's interest. Just give you a very simple example. You are an agent appointed by a couple to buy a house, and you found a property which is perfect for the couple, but problem is, the seller of the property, and that the seller is willing to offer a lower price, because he's in a hurry to sell the property, so he's willing to sell it at a lower price. So at the same time, the seller, since you know him, also offer you something and say, hey, if you sell it, I'm going to also give you something. So what do you do in that case? You need to make sure that your duty is towards the couple who is trying to buy the house. So you need to balance out this duty between the buyer and the seller, because the law holds that you owe a fiduciary duty to your principal. Now, secondly, of course, you also have the duty of loyalty. What does it mean? It means that, you should be loyal to your principal, avoid any conflict. Try not to put yourself in a position where you may be in a potential conflict. For example, if the principal wants to sell the house and you're interested to buy the house, of course, it's very tempting for you to, pretend to be someone else, and buy the house so that you can negotiate, and perhaps you may also even have some insider knowledge about the property, and are you going to use it to negotiate the price? Of course, you can't, because you have to avoid conflict. If you want to buy, you still can, but you need to make it very clear to the landlord that I'm the buyer, and you can negotiate the price. In fact, the Contracts Act sets out certain specific example in which certain transaction will be void, where the agent, when they want to buy certain things from the principal, but they pretend to be someone else. If this is found out by the principal can actually say, I no longer want to sell it to you. Or another example which I have also highlighted is, in the event that the principal wants to sell a house and they appoint you as an agent, you went to the house, of course, you check before you try to sell, and you found out that there's certain things in the house. For example, there's mineral or there's mine, that you can dig out and you can sell. So that actually will increase the value of the property, but you didn't disclose to the principal, and you then initiate to tell the principal, say, hey, I want to buy this house at the price that you're asking. And then you bought it, and then subsequently found out that, hey, actually you knew about all these minerals in the property, which would have increased the price of the property. The Contracts Act specifically say that the principal has the right to void this transaction and take back the house. So as a agent, it's very important for you to know about all this duty, your duty to be loyal to your principal. Of course, you also have the duty to be diligent and care. Since as an agent, you have wide authorities, especially if you are universal or general agent. You may even have powers to bind the principal, to enter into contract on behalf of the principal. So it's very important that you do everything with, that care and diligence, because if there's any screw up on the part of the agent, the principal will be liable as well. So, and of course, more importantly, as part of being diligent, you need to ensure that you have the necessary licenses as well. Of course, for those who are in the property agent, you need to be licensed, in order to earn charge commission and whatever not. Of course, you also have duty of confidentiality, because as an agent, you definitely come across a lot of confidential information about the principal. For example, as a fund manager, you might get access, to the principal's assets, and bank details and all this. So as an agent, you need to make sure that all this information are kept confidential. And then, of course, another important duty is also the duty to communicate and the duty to have a proper record keeping. As an agent, you definitely need to keep all those records, especially, for example, if you're a fund manager, you should know, what's happening with the funds. And for a property agent, you need to know what's happening to all the units, because from time to time, you may update your principal, and especially if the principal requests, you have to update them to tell them, what's happening. If there's bad news, unfortunately, you still have to tell them. Good news, you have to tell them. You have to keep them informed. Because the last thing you want is the principal to come and hold you liable and say, hey, how come you never tell me this? You never tell me that? More is always better. Always keep the communication open, because this duty to communicate and record keeping is also expressly provided under Contracts Act. So you have such a duty as an agent, And of course, you may also need to be transparent and disclose to the principal if you're also agent for other principal, which is very common in property. Where you're not just looking to sell one house, you're looking to sell 5 or 6 houses. So those, of course, you should make clear to all the homeowners to say, look, I also, of course, I'm an agent. I also act on behalf of other principal. But ultimately, when you approach buyer, you need to be as partial as you can, as impartial as you can. Try to offer what is suitable for the buyer, as opposed to the one who is giving you more commission. It goes hand in hand with your fiduciary duty and the duty of loyalty and all this as well. Of course, the last one is to be the duty to be obedient, meaning follow instruction, make sure that, and follow the authority that's given. Make sure you don't act beyond your authority. That is very important. Now, moving on to what, as a principal, what are the duties that you have? Duties are not just for agent. As principal, yes, surprise, surprise, you also have certain duties. And the first one and most important one, of course, is compensation and reimbursement, which is your duty to pay. When you engage agent, they are incentivized to help you achieve certain things because they have commission, or they earn a certain salary. So as a principal, you have the obligation to make sure that you pay them. And if you don't, then you may be liable to be sued by your agent. And of course, in some cases, you may even have to reimburse your agents. I don't think it's common in a property agency, but in other principal agency relationship, when there's certain expenses, for example, traveling expenses or whatever, the principal may have to reimburse the agent as well. Of course, you as a principal, you should also provide the required information and cooperation to your agent. At the end of the day, your agent is still agent. They are not mind readers. In order to achieve your objective, they will need your cooperation. They will need your information. You can't sell a house if you don't give your agent access to the house. If they ask you for documents, they ask you for information, to a certain extent, there is obligation on your behalf to, give them the information. And then when the information are given, make sure you give them the space and time to carry out their duty. Many a times we know principals, you are anxious, or some principal may even like to micromanage. For example, fund manager, some principal wants to know what's going on with the funds. Even if it dropped 1%, they want to know, they want to ask what happened. Or if a property, you put it out for sale for only one day, and the principal come in, chase you, hey, what's happening? Have it been sold? And all this. As much as we understand you are anxious about your dealings with the agent and all this, the point is, if you engage the agent, trust them, they will do their job. Try not to interfere with them, because like I said, agent also have duty to update you. When and when is necessary. Of course, they will give you the necessary update. Just give them the room to do their work, so that they can achieve the objective that you want them to achieve. Now, of course, you also have the duty, of honesty and fair dealing. This goes without saying. Make sure all the information that you share with your agent is correct. Make sure there's no misleading statement, because the agent is going to take your statement and go to town, or go and represent you. Whatever, any wrong thing that you say to the agent, it will be then reflected to what the agent say to third party. So that is also important. Make sure everything you say is accurate. There's no misleading statement. And lastly, which is also one of the important one, is duty to indemnify the agent. What does this mean? Now, agent is appointed to act on your behalf, so they are also exposed to certain suit by the third party as well. For example, you may engage an agent to help you sell certain things. It may not be property, it may be goods. Then your agent, based on this appointment, they go and find buyers, and they manage to find a buyer. And then suddenly you say, hey, I don't want to sell already. Of course, the buyer is going to sue you, or is going to sue the agent. So in this case, the law actually says that you as a principal, you have to compensate, because you've appointed the agent to do certain things for you, and the agent has duly carried out, and you cannot then back up. Of course, if the agent act beyond the authority you've given, then that's something else. We will discuss that in a while. But the point is, you need to know that you have such duty to indemnify your agent. Whatever your agent go out and say and do, and the contract if they enter into, you need to make sure that you are in a position to perform. Because if you're not, then you have to compensate the agent for whatever losses that he has suffered. Now, we move on to some actual cases which have occurred in Malaysia, and how the court have dealt with it. This is important, because these are real life cases, which I think something that we can learn from. Now, the first question that I put forward today is, can there be an agent-principal relationship without a written contract? No. Now, we have been talking about appointment of agent, and the types of agent, and many a times there is no contract. For example, you may talk to a friend, say, hey, I'm looking to buy land. Can you help me check whether you have any land for sale? And if you can find one, I'll pay you commission. if it's just something like this and your friend actually, went and do the work, they refer someone to you and you manage to actually buy the land, can you then say, hey, there's nothing in return, I'm not going to pay you this commission? Can you do that? The answer is yes. The short answer is the court actually recognizes verbal agent principal contract, because under the law, verbal contract is still contract, but of course it's harder to prove because, like I said, it's verbal. Then you have to look at the surrounding circumstances in how you prove that there's such verbal agreement. And in the Court of Appeal case of 𝐓𝐸𝐤𝐢 against �sheikh 𝐂𝐏𝐿𝐷 the court in this case was dealing with precisely a verbal agency agreement. What happened here was the plaintiff was appointed by the defendant as the defendant's sole and exclusive agent to market goods in Middle East. And the appointment was verbal, not in writing, purely verbal, and there is also not a fixed term granted because it's verbal. They say, hey, can you help me go and sell my goods in Middle East? And then the plaintiff say, yeah, sure, I'll do it. Then after that, the defendant 8.5 years in terminated the agency agreement by giving a written notice. Now, before I discuss the fact, can you imagine this? For 8.5 years, both parties operated without contract, just purely verbal. Of course, those days, I think you can, but these days, I don't think so, because people are getting more litigious. Everything is all about black and white these days. But in any event, in that case, it was verbal. 8.5 years in, the principal wanted to terminate the agreement. But of course, the agent said, you cannot. And even if you want to terminate, you have to give me notice. And in that case, the principal only gave them 3 months notice. The agent said, no, you have to give me at least a year because of, over years of relationship. We worked for 8.5 years. How can you just give me 3 months notice, to terminate, Of course, needless to say, the court here struggled to make a decision because there's no written agreement. Usually, if you have a written agreement, it would have stipulated, look, you have to give how many months notice, for how long and how you give the notice and all this. But here, there is no written agreement. It's all verbal. So the court, of course, struggled. But in any event, the court held here that make 2 points. The court made 2 points. One is, of course, verbal principal agent contract, no issue, because the principal has been paying the commission over the 8.5 years, so clearly there is an agreement. But more importantly, they also talk about how do you terminate a verbal agreement. In this case, the court held that you need to give notice, and what is a reasonable notice will depend on the facts of the case. And in this case, the court actually held you have to at the very least give 6 months notice. And in this case, since the principal only gave 3 months, the court actually give compensation for the remaining 3 months notice that the principal have not given. So this case essentially say that you can have verbal agency contract, but my point is why take the risk? Why leave it to verbal? Because there's so much thing that you need to address in your agency relationship. It's not as simple as what is the commission and all this. Like for example, you need to know how do I terminate, how many days notice am I give to terminate, and all this. So my advice is do not ever try to conclude a agency agreement verbally. Now, moving on to the next question: when and how does agent-principal relationship end? So you know that you can appoint an agent through verbal, of course, preferably written. Then now you should know how do you terminate and when do you terminate? And this, of course, you want to ask, is the agent appointed for life? For example, in the case that I've mentioned earlier, when my trial last year, you only appoint the agent to look for tenant for you. He has looked for the tenant for you already. Is he still your agent during the course of the tenancy? To the extent that he can receive notice of termination on your behalf? So these are the important questions the court have to determine. When does the agent and principal relationship end? And the answer can be found in section 154 of the Contracts Act, which essentially said that an agency is terminated by 1, principal revoking his authority, or 2, agent renouncing the business of the agency, 3, business of agency being completed, 4, the principal or agent dying or become of unsound mind. Or 5, the principal being adjudicated or declared bankrupt or insolvent. So what does this mean? Number 1 is withdrawal or termination or renouncement of the agent. Meaning, now as a principal, I no longer want you to be my agent. So I'm now terminating or withdrawing my appointment. You can do this. As agent, you can also renounce from agency. I no longer want to be your agent. It can be mutual, it can be unilateral. But of course, unilateral, you need to make sure that you comply with the terms of the agreement in how you terminate. And also, you need to make sure that as a principal, if you want to terminate an agency agreement with the agent, you need to make sure the agent does not have interest in this whole arrangement. Why I say this is because Section 155 of the Contracts Act actually say, in the event of an agency relationship where the agent has an interest in the transaction, the principal cannot unilaterally terminate. What do I mean by this? For example, you engage an agent to sell certain things on your behalf, and you're saying that his commission will come from the proceed of the sale. So in this case, the agent actually has interest in this transaction as well. So it's not easy for you as a principal to say that, oh, now I don't want to enter into this agreement anymore. So because for the agent, when you engage me and you say my commission and whatever comes from the sale, I have personal interest in it. I would have invested costs, I would have incurred expenses and all this to try to get this deal done. So it's not easy for you as principal to just anyhow withdraw or terminate this agency agreement. So that is something that we should bear in mind. Of course, then there's the second thing which Section 154 I touch on is if there's death of incapacity, meaning of unsound mind. Of course, it's self-explanatory. If someone is dead, there's nothing to be performed. Or even if someone is bankrupt, Section 154 also say if the principal is bankrupt, there's the agency agreement will be terminated. And thirdly, which is also important, is completion of the task. Meaning if the purpose of the agency cease to exist. For example, you engage the agent to do certain tasks and the task has been completed, and that's when the agents and principal relationship end. And of course, the fourth one is also expiration of time. For example, you engage the agent for a period of 3 months for them to do certain things on your behalf. So upon the expiration of the 3 or 4 months, then the agency relationship will end. Now, all this, of course, is provided for under the Contracts Act, Section 154 of the Contracts Act. But my advice is there's no harm in including all this in your agency agreement, to specify expressly when this agency is deemed to have terminated, especially item number 3. Because completion of tasks, what does completion of tasks mean? My job is it only to look for a tenant for you, or does it extend further to also servicing the tenant, dealing with the tenant's complaint, having to communicate with the tenant, look for ask them to pay you rent, all these things? Does it extend to that, or is purely just to look for tenant? That is the most important one, in fact. And also item 1, of course, is important as well in when you can withdraw, when you can terminate the agency. Number 2 and number 4, I think, is pretty self-explanatory as well. So my advice would be for you to insert all these clauses into your agency agreement, despite it being provided for in Section 154 of the Contracts Act. Now, then the next question is, what happened when agent exceed his or her authority? This is a very common question. The question is the principal bound by what the agent do in excess of the authority? And if the agent act in excess of the authority, what are your rights as a principal? And the answer can be found in the Contracts Act, actually. Essentially, the Act asks one question, which is whether the act which the agent had exceeded his authority can be separated from the act which is within his authority. What do I mean by that? I'll explain. I'll give some example. Don't worry. Now, before that, let's look at Section 180. So the answer is, if you can separate the act, the unauthorized act from the authorized act, then Section 180 of the Contracts Act will apply. What does Section 180 of the Contracts Act say? It says when an agent does more than he is authorized to do, and the part of what he does, which is within his authority, can be separated from the part which is beyond his authority, so much only of what he does as is within his authority is binding as between him and his principal. What does this mean? This means that for example, A as the owner of a cargo, you authorize B to, for example, buy insurance for you, in the sum of 4,000. So your agent went and secured insurance for you for 4,000. On top of that, your agent is very gung-ho. He wants to impress you. He said, don't worry, I get you another one. This is more beneficial for you, protect you the better. So he went and go and buy an additional insurance. So what does the contract act say? The contract act say in this case, you as a principal, you are only bound to pay the insurance premium for the first insurance. Because technically speaking, the second insurance is beyond the authority of the agent. You only appoint him to buy one insurance for 4,000. He on his own volition went and bought another insurance. He's very gung-ho. He said, I want to impress you. But don't worry, as a principal, you're not bound. You only need to pay premium for the first one. Now, what happens if you cannot separate between the authorized act and non-authorized act? That's when section 181 will apply. And if you read, it essentially said that the principal is not bound to recognize the transaction. The transaction, you mean the entire transaction. So what does this mean? Let me just give you another example. For you authorize B, for example, to buy certain things. For example, to buy cows. Say I want to open a farm. I need to start. I want to buy some cows. Can you? You are expert in cow. Can you go and help me find some cows? Buy me 50 cows. Then your agent go and look around and around, and then he go find. Oh, okay, he found cows. And then as he's buying the cow, he also say, "Hey, there's horses as well. So since you are starting a farm, I presume you also want horse one lah. Never mind, I buy for you." And then he bought and he paid a lump sum figure, 6,000 or whatever. I don't know what's the price of cows and horse these days, but just assume it's 6,000 or 7,000 or whatever. And when he pay, there's no breakdown. It's not to say that one cow is how much or one horse is how much. There's no breakdown. He just paid the 6,000. And then what? So in this case, this is a situation where the unauthorized act, which is the purchase of the horse, but the purchase of the cow is authorized, but it cannot be separated because you do not know how much is for which. So in this case, Section 181 Contracts Act actually says you can void and not recognize the entire transaction. So again, it goes back to my point. You need to be very clear on what is your authority and make sure you do not exceed your authority as an agent. And as principal, please also make sure that you make clear what is your authority. Don't allow them to go beyond and make it very as specific as you can, So that's on whether, as a principal, I'm bound by my Agents Act, which is beyond his authority. The next question is, what can I, as a principal, do? As much as, I cannot recognize the transaction. Does it stop at that? The agent still screw up. What can I do to, you may want to punish the agent as well? Well, first of all, if the agent acts beyond the authority, this is a breach of the contract on its own. And you may even have the right to terminate the agency agreement depending on the terms of your agreement. And in some instances, if you suffered certain losses as a principal, you may even claim for all these losses against the agent as well. Now, moving on to the next topic, which is misrepresentation by agent. This is a very common issue. In fact, my firm and myself is handling a same exact case of misrepresentation. In that case, where the purchaser had bought certain units, and before the SPA was signed, they were dealing with property agent. Of course, you have sales agent. When developer, they always engage agents to be at the showroom, to sell property. And in that particular case, the purchaser said that, well, the property agent told me that, the unit I'm buying is only for phase 1. And this development is, in few phases. There will be phase 2, where there will be MRT access or they will build MRT station. And relying on that, they enter into the agreement. And then subsequently, he found out, there's no phase 2. And there's no indication of the developer wanting to develop phase 2. So, as purchaser, then I'll say, in that case, I want to rescind the agreement. What the rescission means? It means you take back your unit. I don't want it anymore. Because the reason why I buy is because I want the access to MRT station. I want the phase 2. but it seems like it's not happening and you lie to me, it's not true. So then the question is, can the agent, your property agent who is on the showroom or whatever, make all these promises on your behalf? And if can, what happens if this representation, become untrue? What are your rights as a third party? So the answer to this can be found in many cases. One of it, which I'm going to share today, is the case of 𝐶𝐸 Realties in Amber Heart and 𝐾𝐸𝐸 and 𝐶𝐸𝐸. What happened here was the company, the defendant was a company and was keen to buy a land. And the plaintiff, in this case, owns the land. The plaintiff's estate agent, the agent, actually was the one who was dealing with the defendant. And he made a representation. He told the defendant, don't worry, this land got road to access to the main road, and the defendant believed, and they entered into the contract, and they signed the contract to buy the land. And then later it was discovered that actually the land doesn't have access to the main road. So then the defendant said, oh, in that case, I don't want the land anymore. There's been a misrepresentation and I want to rescind the contract. And in this case, what did the court find? The court find, number one, look, it cannot be disputed that you have an authorized agent, which is Wong, and he did tell the defendant that, the land has access, but this was found out to be untrue. And therefore, in this case, the court found that since the representation is not true, the defendant actually has the right to avoid the contract or rescind the contract. So the defendant can just not buy the land anymore. Of course, there's certain elements on how you establish misrepresentation, which I will not go into, but just briefly, there need to be a representation, you need to rely on it, and all these kind of things. But the point that I'm trying to make here is you need to be very careful when you appoint an agent, and what does the agent tell the third party? Appoint a competent agent, make sure they don't simply make promises, say, oh, this house in 5 years, it will increase 2 times the price. Sometimes agent being agent or sales being sales, they will promise you the sky and the moon. They will tell you everything just to close the deal. So this is very important. You cannot just simply make any representation, because if it turns out to be untrue, the buyer actually has a right to say, oh, now I don't want to buy anymore. So now, moving on to another interesting case as well, which is Amber Heart against KFC Holdings. What happened here is the D2 defendant, there's 2 defendants here. The second defendant issued a letter to the plaintiff, inviting the plaintiff to submit the job for a tender. This is your normal construction job. D2 actually wrote to plaintiff, say, hey, submit tender. We are looking for someone to install, if I'm not mistaken, suspended mineral fiber board ceiling. And this was in Wisma KFC. They given asked the plaintiff to submit tender, and then the plaintiff actually submitted the tender. And then subsequently, the second defendant told the plaintiff that the plaintiff will be appointed. In fact, they prepared a draft letter of award. They went through the letter of award with the plaintiff. And then the second defendant just told plaintiff, yeah, you're going to be appointed already. Don't worry. So in the draft letter of award, there is certain completion date and commencement date. So the plaintiff, based on the representation given by the second defendant, they say, oh, since you're going to award to me, and if I want to catch up time, I better start ordering the materials now. So the plaintiff, being proactive, he went and ordered materials, in anticipation that the contract is going to come and that they can start work. What then happened? What happened was the contract was eventually not awarded to the plaintiff. It was awarded to someone else. Of course, then as a result, the plaintiff suffered losses, especially the materials that he have ordered. And then what happened? Plaintiff sued the defendants. Of course, the first defendant said there's no contract because D2 has no authority. He's not my agent. He's not no authority to tell you whether the contract award or not award. So what did the court find on this case? The court actually found that based on the circumstances of the case, D2 was sort of in a way employed by D1, and they found that there is an agency relationship between the 2 defendants, and they said that D2 is actually an agent of D1. And since the second defendant was the one that told the plaintiff that you will get the job, we are going to issue you the LOA, there is a concluded contract between the first defendant and the plaintiff. This was the court finding. And the court, in fact, also found both defendants liable to pay the plaintiff for the losses that they suffered. And as you will see from the extract, it is said, it is clear from the evidence adduced that the first defendant has been instructing the second defendant in respect of the said work. Clearly, the first defendant retained control over the work designated, and the court said, I'm constrained to hold that the second defendant employers were one of contract of service. Once the second defendant is found to be employed by the first defendant, then clearly the second defendant is the agent of the first defendant. And there's also a judgment of court that the agency agreement, need not be in writing. So again, this was a case where, there's nothing in writing. I think this was a situation where KFC have their related company dealing with the plaintiff, because as KFC, you have a lot of arms, and it's also common among developers as well. They have a lot of arms, where, when they deal with contractors, they don't have the direct, company, the listed company dealing with it. Perhaps maybe it's a subsidiary. So the court said that, that even though there's no written agreement, I still found that there's agency between the two. And, they found that there was indeed a contract that was concluded between the first defendant and the plaintiff. And what happened here, the court said that the plaintiff relied on the second defendant's statement and ordered the goods, and it was found that the contract was subsequently awarded to another contractor and causing loss and damage to the plaintiff. So therefore, in this case, they said, that the court even went further. They said, even assuming that the second defendant might not have been authorized expressly by the first defendant to inform the plaintiff, the first defendant is jointly and severally liable with the second defendant for the representation of the second defendant to the plaintiff. So in this case, it was not a situation where the plaintiff wanted to rescind the contract. There's no rescission. In this case, the plaintiff is just claiming for damages. So as you will see, as an agent, if you make certain representation to people, and if the representation turns out to be not untrue, the third party can either rescind the contract or even claim for damages. So again, I reiterate my point, as an agent, be very careful in what you say, and as principal, be very clear to your agent of what are the authority, and tell them, be very careful in what they tell the third party as well. Now, we have gone through the duties of agent and principal in some cases, in the sections of the Contracts Act, but of course, that is only scratching the surface. When you talk about the principle of agency and principle, there's still a lot to be discussed, but we only have limited time today. Anyway, here's some of the practical tips or key takeaway that I hope some of you will take away with you today. Which is one, please make sure you have proper agreement in place. I cannot emphasize this enough. While case law have said that formal contract is not necessary, you can have verbal contract, but it is always advisable to have everything in black and white, especially when you have complex or significant transaction. If the land is worth 42 million, you're going to get commission of 1 million, that's still a lot of money, and the agreement can set out a lot of things. You can set out the terms and condition, when can you terminate, what is the extent of the agent's authority, what is the agent's remuneration, how do you pay the remuneration, ultimately, when you're in doubt, please consult a lawyer in terms of what needs to be in an agency agreement. Of course, second, make sure your agent does not act beyond the given authority. This goes hand in hand with the first one, which is you set up clearly what is the responsibility, what is the authority, and make sure they don't act beyond. Because if you want to argue to say that certain transaction you're not bound, you need to make sure you make it very clear what is the exact authority given to the agent. And of course, last one, make sure as an agent you have the necessary license, because as most of you will know, as an estate agent, for example, there's express provision under the Estate Act that no person, if you're not registered, you cannot entitle any fees, commission, charges, or remuneration as the estate agent. So it's very important you make sure you're licensed. As principal, you need to make sure that the agent you engage is licensed as well. Otherwise, there will be, the agent will be committing an offense. So that's all we have for today. And here's a bit of background on myself. I would like to again thank everyone for listening, and look forward to more sessions with Excel. And I hope everyone learned a thing about tool about agency and principle. And I'll also have my contact detail there for anyone who has any pressing question or you have any issues. Please feel free to contact myself. And then now I pass it back to Naufa for some Q&A.
All right. Thank you, Mr. Chee, for that content-packed talk. We'll now move on to the Q&A segment where you'll hopefully answer any questions you have on today's topic. So, for the first question, we have a question from Miss Mizadi. What are some of the best practices for enhancing accountability in agent-principal relationships?
I see. I presume this question was asked just before my last slide on the key takeaway. So I will just, I've more or less
I think
highlighted
so.
because there's only some. But ultimately, I think the key thing is just have a constant communication between principal and agent, because ultimately you guys are in this together, you're helping each other. You usually, when you engage an agent, is to achieve certain tasks. The more communication you have, the better it is. You are both working towards a common goal. So if there's one best practice besides the three that I've already mentioned, is to make sure there's constant communication, to keep constantly each other updated, and also attend talks like what Excel Academy is providing, so that you know your duties as an agent and you know your duty as a principal.
Awesome, sir. Thank you. Moving on, we have another question from Miss Nur Atun. How can technology and digital tools be used to monitor and improve accountability in agent-principal relationships?
Interesting question. Unfortunately, I'm only a lawyer. I'm not an IT guy. So I can't comment much on technology and digital tools. But of course, rest assured, there's a lot of potential when it comes to technology. There can be application in which you can monitor the status of what the agent is doing. There's a lot of potential. As far as I'm aware, I'm not sure if there's any apps or software out there at the moment. But I can only speak from a legal point of view, unfortunately, because it's just not within my expertise. But definitely, there's a room to explore. Perhaps, no, Atun, you can consider venturing into developing some of these technology and digital tools.
Right. To add on to the question, is there any that you use or any that you've heard of your clients using?
No, actually not especially. They're still very old school, especially all the property agent. These days, it's just very old school. Everything is WhatsApp, and there's not much as a principal that you can do to monitor what your agent is doing. Of course, when you talk about fund management, it's different. Fund management, you don't need specific tools. You have a website where I can just log in and check how my fund is doing. What are the funds that my manager have sold and buy. That one I think everyone can access. But when it talks about property and maybe perhaps some other agency relationship, perhaps that is not as transparent as it could be, and I would say. Yeah.
All right. Thank you, sir. Next, a question from Miss 𝐒𝐞𝐿. What is the role of accountability in agent-principal relationships, and how does it relate to maintaining trust and preventing betrayal?
I think ultimately accountability is to hold yourself accountable, knowing that as an agent you're representing the principal, and there's been trust that's been given to you, which is why there's a lot of all these duties that have been imposed on agent and also principal. And when you appoint someone, especially when talking about fund manager and even property agent to a certain extent, you're entrusting them with your money, and you're entrusting them with your property as well. So the trust is very important, and when you hold your agent accountable, for example, with all the duties and all this, of course, then you prevent this betrayal and prevent them acting out of authority. And which is why, again, I go back to my point, which is make sure you have a proper agreement which sets out clearly what is the framework in which the agent and principal relationship work. Of course, there's no one-size-fits-all answer. Neither is there a complete solution to prevent betrayal, but there is definitely prevention. And the prevention is having a proper agreement, having proper monitoring system to monitor what they are doing, and proper communication. These are some of the ways to prevent betrayal, I would think.
All right. Thank you, Mr. Chee. I believe that was all the questions we have for today. Once again, I would like to thank you. Thank you so much for that insightful and very comprehensive talk you just gave us just now, and as well as the participants for tuning in today. We hope to see you all in the next one. Thank you, sir.
Thanks, everyone. Thanks, Nafa, for having me again. Take care, everyone. Have a good week ahead.